Crown on the application of Elan-Cane, Appellant, and Secretary of State for the Home Department, Respondent.
This appeal raises two questions. First, does the European Convention on Human Rights impose an obligation on a contracting state, such as the UK, when it issues passports, to respect the private lives of individuals who identify as non-gendered by including a non-gendered or X marker for the passport holder's gender as an alternative to the markers for male and female? And secondly, if the Convention does not impose any such obligation, is such an obligation nevertheless imposed on the Home Secretary by the Human Rights Act of 1998? Her Majesty's Passport Office, HMPO, is an agency of the Home Office which deals with the issuing of passports. It is HMPO's policy that an applicant for a passport must state on the application form whether their gender is male or female. If no gender is stated, the gender that's shown on the applicant's supporting documents is selected. The passport is then issued, recording the passport holder's gender as male or female. People who are transgender, which for this purpose means people who have acquired a gender, either male or female, which is different from the one recorded at birth, can obtain passports showing their acquired gender on the production of a gender recognition certificate or a re-registered birth certificate or a doctor's letter. The appellant was born female, but identifies as non-gendered, that's to say, neither male nor female. In 1995, the appellant contacted the UK Passport Authority, a predecessor of HMPO, to inquire whether it was possible for a passport to be issued without making a declaration of being male or female. The appellant was informed that it was not. The appellant accordingly applied for and was issued with a passport in which the gender was recorded as female. The appellant made similar inquiries in 2005 and in correspondence between 2010 and 2016 with similar results. In 2014, HMPO completed an internal review of gender marking in passports. It noted that there had been very few requests for a non-gendered or X marking other than from the appellant, and that UK legislation, including discrimination and equality legislation, is based on the categorization of all individuals as either male or female. It stated that recognizing a third gender would put HMPO in isolation from the rest of government and society, would have adverse implications for security aspects of the use of passports, and would result in substantial administrative costs. The government repeated these points when it considered the issue in 2016. The appellant argues that the policy operated by HMPO contravenes the right to respect for private life, which is guaranteed by Article 8 of the Convention, either taken on its own or read together with the prohibition on discrimination in Article 14. The High Court and the Court of Appeal rejected that argument. The appellant now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. The central question is whether HMPO's policy breaches the UK's obligations under the Convention. There is no judgment of the European Court of Human Rights which establishes an obligation to recognise a gender category other than male or female, and none which would require the Secretary of State to issue passports without any indication of gender. Applying the principles established in the case law of the European Court, there has been no violation of the appellant's convention rights. The degree of prejudice to the appellant, which is attributable to the unavailability of an X passport, does not appear from the evidence to be as serious as that suffered by the applicants before the European Court in the cases on which the appellant's counsel relied, which were concerned with post-operative transsexuals who were still categorized according to their sex at birth. The appellant's interest in being issued with an X passport is outweighed by the considerations relating to the public interest put forward by the Secretary of State, including the importance of maintaining a coherent approach across government and the legal system to the question of whether, and if so, in what circumstances, any gender categories beyond male and female should be recognized. It's clear that this is a matter in which the states which are parties to the Convention would be afforded a high degree of latitude by the European Court, having regard to the absence of any European consensus, the complexity and sensitivity of the issue, and the need for a balance to be struck between competing private and public interests. Counsel for the appellant argued that even if the European Court would conclude that there was no violation of the Convention, nevertheless, the domestic courts should decide that the Secretary of State was obliged under the Human Rights Act to issue the appellant with an X passport, and that her failure to do so was a breach of the appellant's Convention rights. In that regard, reliance was placed on comments made in a 2008 case before the House of Lords. This court has concluded that those comments are not binding, are inconsistent with a large body of authority at the highest level, and should be disapproved, essentially because they are based on a misunderstanding of the margin of appreciation doctrine of the European Court, and would result in an encroachment upon parliamentary sovereignty, which Parliament is unlikely to have intended when it enacted the Human Rights Act. The Court will now adjourn.